Well, the senior lawyer, Rebecca John, who's been tracking these developments very closely, is with us at this stage. Thank you, Rebecca, very much for speaking to us. Is there any infirmity legally or, with the centre essentially having issued guidelines saying that those in rape cases shouldn't be given remission, and the state government in Gujarat going ahead and saying that these 11 individuals can be granted remission?
Vishnu, there is a background to this case, and I think you need to understand that background. Sometime in May of this year, one of the convicts had moved the Supreme Court in a writ petition asking for the state government to exercise its powers of commutation under Section 433 and 433A of the Code of Criminal Procedure. The Supreme Court, via an order dated 13th of May 2022, in fact, asked the state government to consider their case and within a period of 2 months. So you must contextualize this order, which has come yesterday, in the context of the petition moved in the Supreme Court and the Supreme Court's directive to the state government to consider their plea for release under Section 433/433A of the Code of Criminal Procedure.
So
the
perhaps
Supreme Court
the decision
in that
itself,
order, yes.
I mean, it followed certain legal guidelines. But I think the larger issue over here is it not bizarre or peculiar that in a case as heinous as this, you'd have people out of jail just a couple of years after the Supreme Court, in fact, went to the extent of ensuring that Bilkis got a government job, the government to pay 50 lakhs, she got a house, all of that. So there was relief for her. And now 3 years later, these convicts are out on jail. So while I understand there's procedure in the law, does it not seem terribly unfair to the survivor?
So everything that's legal is sometimes not just. Now, the law clearly says 433 and 433A gives the power to the government, the state government or the union government, to consider in appropriate cases, the release of a prisoner and to commute the sentence from life to a sentence where the prisoner has served a minimum period of 14 years. In this particular case, from the order of the Supreme Court, it appears as though the prisoner has served, at least this particular prisoner served 15 years and 4 months without remission. With remission, of course, it will increase further. So it is not an illegal order because the law permits such kind of release, and the whole principle of commutation is based on the power exercised by the administration to release prisoners who have served time. My difficulty with an order of this kind is the fact that when I argue matters before courts, particularly the Supreme Court, and particularly death sentence matters, and where the Supreme Court sets aside the sentence of death and converts it into imprisonment for life. In case after case after case, the orders say 30 years without remission. Life means the remainder of the person's life. No parole, etc. In fact, in an extraordinary case which was decided on 8th November 2021, in the case of a rape of a 5-year-old child and her murder, the Supreme Court said these appeals are partly allowed by commuting the death sentence to that of life imprisonment, with the stipulation that the appellant shall not be entitled to premature release or remission before undergoing actual imprisonment of 30 years for the offense under 302 and 376. So this is the law laid down by the apex court, where the courts are not in these kind of cases releasing prisoners for a short period of time simply because they have completed 14 years as required by law. Vishnu, let me also say that I am not an advocate of very long sentences. I do believe that if you did an audit of our jails today, under trial prisoners and convicts are serving extraordinarily long periods of time in prison without remission, without parole, without any board coming and commuting their sentences. So what I notice here, and that's the only reason that I oppose an order of this kind, is because I feel that there is disparity and bias in our sentencing procedures, and that must be avoided at all costs. After all, every prisoner, no matter how heinous the crime, must be told this is the period you serve in custody. When you have these kind of wide disparities, then of course it will be questioned. These biases will be questioned. India doesn't have a uniform sentencing policy. Unlike Britain, we do not have a sentencing commission, and therefore it's really the hunch of the bench, or in this case, the hunch of the sentencing board.
But is it also not true, Rebecca, that there are cases where individuals lie in our jails, languishing in jail for years with far lesser, far less severe crimes, and they continue to be in jail, whereas very proactively, you've got a state board in Gujarat which has allowed these people to actually, isn't that wrong essentially?
Which was the point I made just now. Absolutely wrong. You have people who have committed less brutal crimes, sometimes crimes that do not involve the human body, who are languishing in jail for years and years. As under trial prisoners, many of these prisoners have served their sentence and continue to be in jail without bail. And you have a situation here where 7 people were killed, including 2 minor children. This woman was gang raped. And you wait for the 14-year period to be over, and you no doubt make use of the law. I'm not saying the order is illegal, but it is certainly improper. And I think sentencing commissions should look into the gravity of the offense before they release prisoners. And if they seek to release prisoners, then that kind of release should be given across the board to everybody who face similar allegations.
You know, a final question, Rebecca, just looking at this from the perspective of Bilkis Bano herself. This is what she said a couple of years back, and I quote, "The Honorable Supreme Court has let me know it stands with me. It understood my pain, my suffering, my struggle to regain the constitutional rights that were lost in the violence of 2002. No citizen should have to suffer at the hands of the state whose duty it is to protect us." This same woman, after the ordeal that she went through, is in a situation now where the men who nearly killed her are out. Is this not, beyond just the law itself, which you've explained so lucidly? It just seems terribly unjust.
Yes, and that's what I said. Everything that is legal is not necessarily just. And one must feel for what Bilkis has gone through. When I read her judgment today, earlier this evening, it's frightening, the brutality that she faced that morning at the hands of this mob. However, I will say, Vishnu, again, that what I am asking for as a lawyer is uniformity in sentencing. I don't think we should let ourselves we mustn't look at the facts of individual case when we decide what is just and proper and what are uniform guidelines. And as horrific as this case is, I repeat that it is time we have uniform policies.
Yes.
What applies to these people must apply to others. And it shouldn't be a case where some poor person suffers 30 years of incarceration without parole or remission, and these people walk out after 15 years of incarceration. That is terribly unfair.
Rebecca, thank you very much for speaking to us, explaining that, how the law works and how the policy of remission, there needs to be some sort of parity across cases in this country. Thank you so much for explaining that, and thanks very much for being with us.